to this week's episode of On Record PR, where we dive deep into the strategies and insights that matter most to law firm leaders. I'm Jennifer Simpson Carr, and I am here with
Gina Rubel.
Morning, Gina.
Good morning, Jennifer. I think we're laughing because we're in the same room, but we're not going to be talking about laughing matters. We're coming to you from
Legal Week.
up in New York City. And it's really interesting because the energy is a little palpable, isn't it?
Yes.
So if we look at each other, that's why, because we're in the same room.
And if you're listening, you won't see our interactions, but just know that we're sitting next to each other and recording. So today is Monday, March 24th. We are joining you from Legal Week in New York City. As Gina said, the feeling is a little bit heavier than I ever remember at a conference around tech that is so energized and excited about innovation and what's coming in the legal industry. So today we're going to be talking to you primarily about the executive orders that have come out. They seem to be coming out right before the weekend. And we're also going to dive into the crisis communication strategies that we're working on with our clients to help them prepare for what we anticipate might be coming down the pike, though at this point, it's anybody's guess.
This one's going to be fast and furious, folks, because we want to get down to the conference. We're also going to provide some information from the conference. So keep an eye on our various content channels. That being said, it's really important that we address the elephant in the room.
Yeah, so Gina, the latest executive order was issued on Friday, March 22nd. It was titled Preventing Abuses of the Legal System and the Federal Courts. It specifically names Marc Elias and his firm, which at this point, until this point, it's been big law. It's mentioned other big law, and now we're talking about a DC-based firm that is 15 partners and maybe 50 attorneys. So what's the feeling?
The feeling is nobody's safe and everybody needs to prepare.
Yeah.
And I think it's important to realize that this is a game changer, and there's a reason why the current administration puts out these executive orders late on day on Fridays. This is actually a strategic tactic. It's a tactic that even in public relations and crisis communications we use, so we're very familiar with it. But it causes stress, right? It minimizes, or it's supposed to minimize the play from the media because, people don't work 24/7. But if you talk to any of our colleagues, especially in the legal media, legal journalists, they're working around the clock. So that's not going to stop our colleagues from talking about this. However, law firms are not supposed to be working on weekends, right? We're supposed to have, supposed to, I don't know, work-life balance doesn't exist these days. But what's happening is everybody's scrambling on the weekend now. It's creating panic. This is a tactic, right? So which means that a crisis, planning in advance is super important.
So before we dive into the planning itself, let's talk for a minute about some of the language used in this latest executive order. I'll read just a quick excerpt. I hereby direct the Attorney General to seek sanctions against attorneys and law firms who engage in frivolous, unreasonable, and vexatious litigation against the United States or in matters before executive departments and agencies of the United States. Gina, as we were preparing, we were kind of picking apart the language used. What are your thoughts?
Well, it's interesting. Frivolous actually has a very specific definition and can be proven factually. The second word was unreasonable. Who defines unreasonable? What does that mean? I'm pretty sure that there's no real legal definition of unreasonable. I have to go back and look. I could be wrong. But then you get into vexatious, which kind of means the same thing as frivolous, but it goes a little bit more into it. Do you have the definition up?
Yeah, so it refers to something that is intended to cause annoyance, frustration, or distress. In legal terms, it describes actions such as lawsuits or legal motions that are brought without sufficient grounds, often to harass or burden the opposing party rather than resolve a legitimate dispute.
So it's pretty interesting, right? That's basically what they're doing, right? The administration is doing that very same thing. So folks, if you're answering it, and I'm not giving legal advice, but I would say that these are pretty vexatious accusations against law firms?
We've been very busy as an agency supporting our clients with really kind of, first of all, understanding what all of these mean and how they impact firms and attorneys, but also planning for what might be next. So can you walk us through how we're responding to clients when they are calling us and saying, what do we do next?
I want to go there, but I want to mention something as well. The chairman of Paul Weiss, and I'm going to pulled up a statement, and I want to mention this, and it goes into my answer to your question,
Okay.
Jen. According to American Lawyer Media's Law.com International, Paul Weiss, chairman, said, it was very likely that our firm would not be able to survive a protracted dispute with the administration. And that's really sad, but I think we have some data that supports that decision and why they made the decision they did.
Yeah, it's interesting. So one of the attorneys representing Perkins Coie actually was quoted in CBS News saying that 25% of Perkins Coie's work is government related. So unfortunately, we're in a situation where something like an executive order could cripple a law firm.
And the reason why I want to bring that up is because every firm has to make a decision based on their own best interest. However, I really do believe that if law firms don't have that data about the 25%, other law firms making a decision whether or not they're going to sign the amicus brief or how they're going to address this. So that makes sense, right? If 25% of their business, way too many people will be losing their jobs. So they made a strategic decision and shared the reason. And I think that's important because while I don't like their decision from the perspective of many other law firms may see this as a template for how they're going to respond, it also was in their best interest. And that's why he said that. And I think that's a smart communications move, that transparency. It doesn't make it any better because basically it feels like blackmail. Okay, I'm just saying it feels like blackmail. And for the lawyers listening, you know why I'm saying feels like and not is, because that could turn into defamation. And so, but it's what it feels like. There's a perception there. But to go back to what law firms should be doing, if you don't have a strategic crisis plan, if you didn't create one after COVID, at least create some plans on how to address potential orders that might come down against you or your colleagues. Scenario planning is key. We've talked about that on many of our podcasts. What does that mean? Well, it means what if an executive order comes down this Friday on XYZ because we represent or somebody who was here in the past has represented. And then that's what a scenario looks like. You have to know who your rapid response team is, or we also call that incident response team or crisis response team, all the same. Who is on that? Obviously, it's your EC. It absolutely 100% should involve your senior level marketing and comms professionals. Too many times, executive committees leave out their crisis comms people who have to do the work, right? If a statement has to be issued. So that's, you know, in your in-house counsel, outside counsel, make sure that the law firm that represents you, your outside counsel, is willing to speak to the media if you want them to issue a statement on your behalf. Although I don't think that's in anybody's best interest right now either. I think, you know, having the chairman of the firm or the managing partner of the firm do it is going to be really key right now. Have your preemptive messaging ready. Know who the media, who the reporters are that you want to be contacting. Have their contact information. You know, get their cell phones, and there's ways to do that. And if you know, this isn't about sales. I'm not here to sell you a PR firm. If you can't afford a PR firm, call me, email one of my colleagues. We'll tell you who you need to have on your list. This is not a time for us to be competitive. It's not a time for us not to be helpful, right? Yes, we get paid for that, but at the end of the day, if you're a small firm and you need to have that information because you're fearful I will happily put you in touch with our colleagues in the media.
So Gina, can we pause here for just a minute for a message from our sponsor?
Of course,
And then we will come back and finish our recommendation.
because I'm like boom, boom, boom.
This episode is brought to you by Furia Rubel Communications, a public relations and marketing agency serving law firms and businesses worldwide. With an expert team positioned throughout the U.S. and supported by an international faculty, Furia Rubel enhances our clients' brands through integrated communications by providing expert guidance in crisis management and high-profile litigation, protecting brand and reputation, and supporting internal marketing teams. To learn more, visit furiarubel.com.
Okay, we're back from our sponsor message. So let's pick up where we left off with recommendations for law firms.
So Jen, some of the other things are, having your thought leadership, knowing who you're going to be talking to, as I said, know how you want to be perceived, how are we going to handle these things? And it changes from day to day. We know that, but you could, again, have scenarios, if this, then that. And we did that, by the way, folks, in law school. We do if this, then that all the time when we're preparing anything from how we want a transaction to play out to how we want litigation to play out. Know what your risks are and be prepared to mitigate those risks. What I like to call litigation readiness. You need to be ready to litigate. You may even have some preemptive language ready to get into responsive filings if you're going to respond. And again, I'm not going to give legal advice. It's my understanding, like on the EEOC letters, that I believe that I've read this, that you don't have to respond, but we'd have to talk to the proper attorney on that. That's not an area I've ever practiced in. But really, another really important thing is internal morale. Your professionals in your firm, from the person in the mailroom and the library and the people at the reception desk to your most senior executives, people are not comfortable right now. We saw what Rachel Cohen did at Skadden. Shout out, Rachel. You are an associate hero in the industry, and you're a brave woman, and really proud to see someone standing up for themselves and their colleagues and what they believe. But the other thing is, Jen, even legal professionals from every level in law firms are afraid even to say on LinkedIn, for example, this is how I feel, even if it doesn't reflect the position of the firm, because they're afraid they're going to lose their jobs. And I'm hearing that daily. And, the question is whether or not, if a law firm lets somebody go for speaking out in their own First Amendment right, is that going to cause those law firms to end up with retaliation lawsuits, key tam lawsuits, things like that? So, I say this often, and for those of you who don't like the word, I just don't have another cliche to say it. You're damned if you do, you're damned if you don't. It's a catch-22 for law firms right now.
So let me ask you a follow-up question on the internal piece, because what's been interesting in reading a lot about, what's transpiring is, what are your thoughts on a scenario plan for a disgruntled employee or someone who has been let go, potentially being a whistleblower?
Well, these are the types of scenarios that law firms, especially big firms that have crisis plans, should already have in place. It's a typical scenario. We see this all the time. This is nothing, that scenario is nothing new. So if you haven't planned for it in the past, you should be planning for it now. That's really important.
Yeah. So any parting thoughts before we conclude the episode?
I think it's what's most important is that you be planning for what could happen to your firm. You need to be evaluating all your matters. If you are a firm that we call, and forgive me, but this is true, like a hotel for lawyers, where you're a decent sized firm, but all the practice areas work on their own, they bring in their own matters, you don't have a CRM, you really need to be asking questions like, who are our clients? What are our risks? You need to be talking to one another. This is another great reason why law firms should have CRMs, because somebody should be able to pull all that data and say, these are our clients, these are all the risks. This is the pro bono work we've done. This is our DE&I programming. This is where our risks lie, and be able to start planning scenarios under those risks. But most importantly, keep your heads up. We're going to work through this as an industry. There are many people who care about the industry and we want to see it survive. Certainly I do, as a third generation lawyer in my family. But know that we're going to keep coming to you with resources that help through this unprecedented time.
Thank you. Thank you to our listeners for tuning in. Thank you for submitting questions. They've been incredibly helpful as we think about content to bring to you that is going to provide you with insights that you need to do your job effectively and maybe have different perspective than you're thinking of on your own. If you've enjoyed this episode or any episode that you've listened to, please consider leaving a review on iTunes. It does help boost our show. We will see you next Monday. And
if not sooner,
as Gina said, please keep an eye out for content coming out from the week this week. Thank you.
bye.
On Record PR is produced by Jennifer Simpson Carr and Matt Henderson, with support from the team at Furia Rubel Communications. This episode is edited by Isabel Horan and Christian Yamula. Visit www.onrecordpr.com for resources and more information.